So, the hit reality TV show on TLC called Unexpected, that followed the lives of teens that became unexpectedly pregnant, has been causing a lot of controversy, specifically with two of the cast members by the name of Bella, who is 15 years old, and Hunter, who is 13 years old. Now, these two have been together since they were very young. I mean, like, around 11 years old. And I don't know who allows their kids to date at that age, but apparently it wasn't an issue for at least most of the parents involved. Bella was only 14 years old when she became pregnant with her child, and her baby daddy, Hunter, was only 12 years old. And they welcomed their son into the world at just 15 and 13 years old. So these two have spent a lot of time together, with Hunter being allowed by his mother to spend nights over his girlfriend's house. It's no wonder they became with child. And by these kids being on the Unexpected reality TV show, it has opened them up to a lot of scrutiny. A lot of people were outraged by the behavior shown on the show, and one of those people just so happened to be Hunter's dad, Casey. According to him, he did not agree with his underage son being allowed to spend the night at his girlfriend's house. And he also didn't agree with a lot of things that the mother allowed him to do. So, as of April 2026, Hunter's dad, Casey, took it to the courts and filed for custody over him. We have the documents, the judge has issued an order, and we got to get into this. So, y'all, buckle up. The first document on the screen was electronically filed in Crawford County Circuit Court on April 7th, 2026. The motions were filed in an already existing child support enforcement case, so you will see both parents of Hunter listed as defendants. The father will be Casey D. Johnson. He is the first defendant. The mother is Stacy D. Riddle, and she is listed as the second defendant. And the document reads, First defendant's amended motion for custody and request for expedited hearing. And it says, comes now the first defendant, Casey D. Johnson, by and through his attorney, Carrie L. Jernigan, and for his amended motion for custody and request for expedited hearing states as follows. Number one, the defendant and second defendant are the parents of a minor child born in 2011. Number two, the parties separated in or around 2013 and for several years thereafter successfully co-parented the minor child without the need for court intervention, sharing custody on an informal basis. Number three, in or around 2017, the second defendant entered rehabilitation for substance abuse issues, at which the time the first defendant exercised primary custody for the minor child. Number four, by approximately 2018, second defendant had achieved sobriety and the parties resumed a shared custody agreement. Number five, in or around 2021, second defendant was unable to maintain stable housing or provide adequate structure for the minor child. As a result, the first defendant allowed second defendant to reside in the home with him, his current wife, whom he married in 2017, his other child with his wife, and Hunter, in order to provide stability and support. Number six, under information and belief, after second defendant later obtained separate housing through a HUD program, she was subsequently evicted from the resident due to related drug use. Following such eviction, the minor child primarily resided with first defendant during his fifth through seventh grade years of school. Number seven, while in first defendant's care, the minor child performed well academically and was actively involved in extracurricular activities. First defendant's home has consistently provided a structured, stable, and supervised environment, including appropriate monitoring of the minor's child activities. Number eight, beginning in or around late 2023 and continuing into 2024, second defendant began allowing the minor child unfettered access to a cellular phone, social media, and relationships beyond what is appropriate for his age, including permitting him to engage in a romantic relationship without reasonable supervision or boundaries. Number nine, first defendant maintained reasonable and age appropriate restrictions regarding phone usage, social media, and dating. However, second defendant undermined those efforts and in or around 2024 removed the minor child from first defendant's care and began denying first defendant meaningful access. Number 10, due to the absence of a formal custody order at the time, second defendant was able to do so without immediate legal remedy, and first defendant subsequently filed for full custody in April of 2025, though service was delayed for a few months due to not knowing the second defendant's new address. Number 11. During this period, the minor child impregnated his girlfriend, and upon information and belief, was allowed by second defendant to reside in the girlfriend's home over first defendant's objections. Second defendant repeatedly interfered with first defendant's ability to exercise parental authority and make decisions in the minor child's best interest. Number 12. The second defendant further permitted the minor child to participate in a televised program unexpected on TLC over first defendant's objection. First defendant did not consent to the minor child's participation and believes such involvement has further exposed the minor child to inappropriate influences and public scrutiny. Number 13. In an apparent attempt to further interfere with first defendant's relationship with the minor child, a hotline report was made to the Department of Human Services against first defendant. Said report was investigated and ultimately unsubstantiated, and first defendant believes it was made in retaliation for his pursuit of custody. Number 14. On or about November 18, 2025, the parties entered into a temporary agreement providing for a week on, week off custody agreement. Number 15, the court further ordered that the minor child and his girlfriend were not to stay overnight together. Number 16, despite this, first defendant has reason to believe that such overnight contact continues in violation of the court's orders. Number 17, first defendant has significant concerns regarding the minor's child's education in the second defendant's care. Upon information and belief, second defendant has failed to ensure the minor child attends school regularly, resulting in excessive absences and declining academic performances. Number 18, the first defendant even requested the temporary order in state in paragraph 14. Both parties shall make sure the minor child attends school daily unless there is a valid reason for missing illness ethic. Both parties shall keep the other parent notified of school issues and work together to make sure the minor child completes all schoolwork. Number 19, first defendant has required constant school attendance and appropriate accountability. However, second defendant has failed to do so, resulting in excessive absences and low grade. Number 20, since the airing of the television program, first defendant has become aware of additional concerning conduct occurring within second defendant's parenting time, including lack of supervision, lack of monitoring, and permissive behavior that places the minor child at further risk. Number 21. First defendant is concerned that second defendant, in conjunction with the girlfriend's parents, is failing to impose appropriate boundaries and may be facilitating continued inappropriate conduct, including the risk of an additional pregnancy. 22. There is clear and convincing evidence it is in the best interest of the minor child that custody is awarded to the first defendant subject to reasonable visitation. Number 23. Second defendant's household lacks appropriate supervision, structure, and parental guidance and permits conduct inconsistent with the minor's child age, maturity, and responsibilities. Number 24. First defendant provides a stable, structured, and supervised home environment, enforces appropriate boundaries, and prioritizes the minor's child education, development, and overall well being. Number 25. First defendant requests that this matter be set for an expedited temporary hearing at the earliest available date. Number 26. Immediate court intervention is necessary due to A, ongoing violations of court orders, B, educational neglect and excessive absences, C, lack of supervision and appropriate boundaries, and D, continued risk to the minor child's welfare. Number 27, without prompt relief, the minor child remains at risk of continued harm and instability. Respectfully submitted by his father's attorney. So that was the first motion filed by Hunter's father, Casey. And so I'm going to get into what was ordered by the court. The next document is on the screen. We can see that it was electronically filed in the Crawford County Circuit Court on yesterday, April 24th, 2026. And the document reads, Order for Emergency Ex Parte Relief. On this day of April 2026, the court considers the motion filed by the first defendant, Casey D. Johnson, seeking an emergency order pursuant to Rule 65 of the Arkansas Rules of Civil Procedure based upon the verified petition in all matters before the court. The court does hereby find an order as follows. Number 1. The requested emergency order is hereby granted, and the court finds that the circumstances set forth in the verified petition for emergency ex parte custody and other relief and requests for emergency hearing filed by the first defendant warrants an emergency situation, placing the minor child at imminent risk of harm should he be returned to the second defendant. Number 2, that as a result, the court hereby finds that the second defendant's custody shall be suspended until such time that this matter may be heard by the court. Additionally, the minor child, Hunter, born 2011, shall remain in the custody and care of the first defendant pending a hearing in this matter. Number 3, the court further finds that irreparable injury or harm will occur without the entry of this emergency order, that the entry of this emergency order is appropriate due to the reasons outlined herein. Number 4, the following restrictions shall be in effect immediately. A, the court enter an injunction for relief and prohibit the filming of the minor child and further prohibit the posting or dissemination of any videos, images, or other content on any social media platform, whether on the minor child's account or any account controlled by another individual. B, the second defendant not be allowed to permit the minor child to be publicly used in social media disputes or litigation related content. C, that the second defendant should be required to cease all unnecessary law enforcement calls and harassment directed toward the first defendant. D, that Falen Vaughn and Chris Vaughn should have no contact with the minor child pending further order of the court, or alternatively only supervise contact at the first defendant's discretion. E, that the parties and all family members should refrain from aggressive confrontation, yelling, or disturbances in the presence of the minor child. F, that the minor child should comply with reasonable rules and directives established by the first defendant during the second defendant's custodial periods, and that phones should not be allowed by any third party or by Falen Vaughn or Chris Vaughn. And G, the second defendant should be ordered to get Hunter to school every day and make sure all of Hunter's schoolwork is completed and turned in on time. Number 5, notice to all parties in interest, including law enforcement. This emergency order is issued on the date and time filed marked above. Every temporary restraining order issued without notice expires at the time after entry, not to exceed 14 days, that the court set unless before the time the court for good cause extends it for a like period, or the adverse party consents to a longer extension at the hearing set by the terms of this 23rd emergency order. The party who obtained this emergency order must proceed with the motion. If that party does not, this emergency order must be dissolved. This matter is hereby set for emergency hearing on Thursday, the 7th day of May, 2026 at 1 p.m. Number 7, this order shall not expire in 14 days. Number 8, bond shall be set at $0. It is so ordered by the Honorable Circuit Court Judge, and we see it has a signature. The courts have sided with Hunter's dad. They have suspended the custodial rights of the mother, and they have even listed that his baby mama, Bella, parents cannot have any contact with him. So that is the Falen Vaughn and Chris Vaughn that is mentioned in item D. Don't forget to smash that like button, drop down in the comments, and let me know what y'all think about all of this. I'll see y'all in the next one. Bye.